It is live streaming now. All right, I'll go ahead with you. Thank you, Keshav. Thank you. Namaskar. Welcome to today's free community class on law, hosted by Team Vestralex. I sincerely thank them for hosting today's free community class on law on the topic of civil practice and procedure. Our guest speaker for today is Mr. Jamshed Pesi Cama, the senior advocate. Mr. Kama completed his graduation from St. Xavier's College in Mumbai in 1970. He thereafter went on to complete his degree in law in 1973. He enrolled himself at the Bar Council of Maharashtra in 1973 and started his practice. 2 years into the profession, Mr. Kama went on to become a qualified solicitor in Mumbai. And then in 1978, he went on to become a qualified solicitor in England. Mr. Kama was designated as a senior advocate in 1991. He primarily practices in the Supreme Court of India and the High Court of Judicature at Mumbai. Some of the important cases dealt by Mr. Kama and represented by Mr. Kama are Isha Steel Treatment, Bombay versus Association of Engineering Workers, reported in 1987, Supreme Court 1478. This is one of the early judgments on the concept of functional integrality of companies under the industrial law. Another important case is Bini Limited versus V. Sadasivan, reported in the year AIR 2005, Supreme Court 3202. This is again an authoritative judgment of the circumstances under which writs can be and cannot be maintained under private parties, against the private parties. The list goes on, and therefore I shall pause here. And given the time constraint, I now request Mr. Kama to join us for today's class. Before parting, I humbly request all the participants to keep them on mute and direct their questions in the chat box after our guest speaker has concluded. Welcome to the class, sir. Thank you. I request you to take over.
Thank you. There is a saying I read by an English author which says that blessed is he who has found his work. Let him ask no other blessedness. For those who are interested in the practice of law, I would say after all these years of experience that as far as I'm concerned, there is no greater blessedness. The practice of law is not for everybody. It is something which must come from the gut. Many often youngsters ask me, should I take up the law? Should I go to the bar? Should I become an attorney? These are questions which people often ask me. And my answer has always been, don't approach it with your head. Approach it with your gut. Do you like it enough to want to work 14 and 18 hours a day, at least in the beginning of your career? So if you are, like I remember in my younger days when I was starting out to practice, I just could not wait to get into a court. I did my solicitors in 75 in Bombay and then worked for a year or two as a solicitor in Bombay. And I found that my friends and colleagues at the bar who were of my age were getting on. I could not wait to leave the solicitor's firm, join up with practice and start. So you have to have that gut which wants to say, I want to stand in a court of law. I want to argue. If you have that in you, then you are likely to succeed. So therefore, if I may put it in another way, the profession of law is a calling. It is not a job. If you look upon it as a job, you will be there. You will be a part of the profession. But in my opinion, you're not going to make it to the top, because to get to the top, it has to be a passion. Now, it is, as I mentioned earlier, let me put this way. In our profession, we always say the law is a jealous mistress. It is. I've had problems in my own younger days when my wife couldn't understand why I would not come home at a reasonable hour. But then if you're building a practice, there is no such thing like a reasonable hour. If you want to make a success of it, the practice of law demands that you put in a lot of effort. There is no shortcut to success. But having said that, I'll remind you of what we were told in law college. We were told, work hard, there is always place at the top shelf. There's always place at the top shelf. Because unfortunately, out of, let us say, 100 people who qualify, about 50 will go into some firm or the other. The balance 50 will practice. And out of the balance 50, about 15 will be what one might call successes. So therefore, it's a very demanding and jealous mistress, and it demands a lot of work in order to start making a success of yourself. Later on, as you become senior, you can delegate some of the hard work to your juniors, which is what all we seniors do. We get lazy as we get older, and we demand that our juniors do the grunt work for us. Now, there are, in my opinion, two kinds of lawyers. There are lawyers who follow the law, who will say, okay, this is what the Supreme Court says, or this is what the High Court says, and this is the law. But there are another kind of lawyer, and I will put that in the 5% bracket, who will approach a problem by saying, why can't it be done? Not that the Supreme Court says this or the High Court says that, but why can't I find a way out of this problem? And that 5% are the people who move the law forward. Law is not stationary. Just as society changes, law also changes. And there are lawyers who have changed the law along with society. As an example of this, you look at the writ jurisdiction. When I began practicing years and years ago, we could file writs only against governments and statutory corporations. Thereafter, it expanded to cooperative societies. Thereafter, expanded to government companies. And now it is extended to the extent that you can even file a writ against a private party for performing a public function. So therefore, there's always been lawyers who are willing to push the boundaries. Law, I want you to understand, law is not made only by the legislature. Law is made more often than not in the courts. How so? When you get a legislation in your hand and you want to challenge it, or more importantly, you want to interpret it, there lies your genius. There lies your capacity as a lawyer. You have to interpret it in such a manner that it expands the meaning of what is meant out there and brings out the true effect of the law. The parliamentary draftsman is often the cause of all problems in this country. They draft badly. They draft in a manner which makes it almost impossible in some cases to find out what exactly do they mean. And this is where a lawyer comes in. This is where a lawyer comes in and persuades a court to believe that the law is clear, that the law means and should mean what he is advancing as an argument. Now, if you can do that, then you will be part of the legislative process. You will be making law. And I always advocate to people, make law. Don't just follow the law. Following the law is easy. So if I had to give any advice today to all of you, my advice would be part of that 5%. Be willing to think out of the box. Be willing to challenge yourself in facing a judgment. Be willing to go to the court and ask the court to change his judgment. In Supreme Court, it's easier than the High Court. You go to the Supreme Court and you satisfy them with the judgment in issue is not correct for a variety of reasons, and they are willing to sometimes look at it again. But these all require ingenuity and a willing to push the envelope. Now, there is a subtle difference between pushing the envelope and saying something stupid. I don't mean that you should go to the extent that your submission becomes absurd. If that happens, then you look foolish. But never ever have the fear that I can't be done. Never have the fear that the court will hold against you. Because what happens? If the court holds against you, you lose. It's all right, but you've tried. The next time, before a different bench or a higher bench, you may succeed. So let not failure of an argument or failure of a submission put you off. If you honestly believe in it, and if you have taken the trouble to research what you're saying, then I would recommend that you never ever be afraid to argue what you genuinely believe is correct. I repeat, at the very highest, the court will say no. But if the court says yes, then you have moved the law. And that is your purpose as a lawyer also. You represent your client by all means, but you also represent the concept of law, the belief of law, the advance of law. As lawyers, I don't believe we are there only to follow the law. I believe that we are there also to make the law. Now, constitutional law. I don't know how many of you are doing or want to do constitutional law. That is my pet subject. I mean, I enjoy arguing constitutional law. And as it happens, fortunately, even though I specialize in labor, I'm often required to argue constitutional points of law, especially when I'm challenging a provision or interpreting a provision. Then in those cases, you challenge the law and you look into constitutional law. Of all the branches of law which I like, I mean, I've done civil suits and all, that's all right. I'm sure that there is a lot to be said for lawyers who practice in pure civil litigation. But speaking as a person who does labor and who does constitutional law along the way, I personally believe that it is the most dynamic law. It is the one branch of law which allows a lawyer and a court to control the absurdities and arbitrariness of the government. And I find that particularly satisfying. Now, I don't know how many of you have noticed this, but today, the courts of the country are largely governing the country. Now, sometimes I do believe that they're going too far. Sometimes I'm genuinely worried that a situation might arise where the government will say, we're not going to follow you. And in some cases, they have done it. But if you want to make a difference in society, then of course, I'm not for a moment saying that civil litigation per se does not achieve some part of that objective also. But ultimately, it is the writ jurisdiction which, in my opinion, keeps the government within the bounds of its own duty. Sometimes, as I said, we go beyond. Courts go beyond and enter the pure legislative field, which is perhaps not correct. Today, how many of you realize that despite the shortcomings of the courts, the delays, we still have a democracy in this country only because of the constitutional courts. The only thing which the courts listen to are the constitutional courts. I remember earlier, a client of mine had walked up to me. He was in a government corporation. And I told him, what are you doing? This is contrary, what you're doing is contrary to your own rules. So he said, yes, sir, it is. We know that. Let the High Court of Bombay say so, we'll do it. So today a situation has arisen where the courts are to a large extent governing the country. And I again say that the final arbiter for democracy in this country are the courts of law. Never ever doubt that, never ever let anybody say less than that. The only way a person can criticize the courts is because the courts have given him the liberty to speak. Now today in our country, there are people who feel an erosion of liberties, an erosion of the capacity to speak freely. They believe that. Whether it's true or not, I'm not going to enter into that. But let me say this, that if it were to be ultimately true, and if a situation arose where it needed to be checked, the only place that could be done is not on the streets necessarily, but through the courts. There's the famous case of the newspaper company, I think it was Express Newspapers at one time, when the government sought to control the newspapers by, if I'm not wrong, prohibiting their own departments from advertising it or in some manner reducing the advertising income. The court struck it down. Your freedom of speech is assured. where you have the Constitution bench of the Supreme Court saying that there is a certain limit beyond which the legislature will not go, where they say your fundamental rights are supreme, where they correct the legislature and the government and its various arms through the mandate of Articles 14, 16, 19, and even 21. How many of your liberties have been granted by these articles? How many of them have been granted beyond what was originally contemplated by them? Freedom of speech is all very well. Education, where do you get the right of education? Article 21. So therefore, the courts of which you are proposing to become parties are the institutions which deserve the highest respect and of which I am extremely proud to be a part. Don't let anybody ever make you feel that the courts are not doing their job. Remember that 30% of the court's problem lies in vacancies. Today, across the country, if I'm not wrong, about 30% of the total sanction strength of all the high courts is under. Now, if you have a situation where you have less judges than what the situation demands, don't blame the courts. Blame the government squarely. And I say government because I'm of personal opinion that the government, being the largest litigant, is not overly keen to appoint new judges if they can avoid it. So therefore, don't blame the courts, blame the system. I see no reason why if a vacancy falls due on a particular date, now you know a judge is going to retire on a particular date, 62 in the High Court, 65 in the Supreme Court. There is, to my mind, no reason why the next person cannot be kept ready. There is no reason why an appointment should take 9 months from the time a name is announced to the time on which it is ultimately sanctioned and the man or woman takes charge. So when you talk about the practice of law, you are faced with these problems. Look at the enormous frustration people feel. People, I have clients who have come to me in the year 1981 and 82, and they say, sir, our members are dying, union members. At that time, I used to do a lot of union work. They say, our members are dying. What do you want to do? And I said, what do you want me to do? I can only move the court and request an early date, but the courts are overwhelmed. So let's not blame the judiciary. We as lawyers are also somewhat responsible. We also delay, no doubt about it. But at the end of the day, the judiciary is doing a tremendous job. When you look at the kind of work that the Supreme Court judges do, I don't know how many of you are familiar with it, but they have admissions on Mondays and Fridays of new matters. An average judge will have 50 or 60 matters on his board. And each one of those matters is read by the judges before they come to court. After they finish with that, Tuesday, Wednesday, and Thursday, they take up final hearings. Then they deliver judgments. So the work that they do is tremendous. I remember once telling a bench of the Supreme Court that I would never want to be a Supreme Court judge. They were rather offended. Why not? I said, because the amount of work you have to do is not funny. Even the High Court, they have to take up matters for admission, they have to hear matters, and then they have to deliver judgments. So the practice of law has its problems. It is frustrating at times. Justice gets delayed. But the system of justice, the practice of law, is a noble one, truly speaking. We have our black sheeps. We have people who are unethical. But at the end of the day, look at the big picture. Don't look at the individuals. Now, each lawyer in his time has certain cases which he or she finds memorable. And if I had to look back on my years of practice, there are only two of which I think are, to my mind, truly memorable. One was the case of this young girl who had appeared for an exam in Bombay, university exam. She was a topper through and through. But there was cheating being done in the university, at the university level. So what they had done, as the court record seems to suggest, is that they had altered the marks, not only of the people who wanted to alter the marks so that they could pass, but they also altered the marks of the students who were first-class students with a view to demonstrate that the alteration is not only among the failures, but is also among the toppers. The consequence of that was ultimately when this was discovered, the university scrapped the entire exam and rusticated the whole lot. Matter came to the High Court. We succeeded here, and the matter went to Supreme Court. Now, in the meantime, this young client of mine had got admission into college based on her record. If she had lost in Supreme Court, she would have had to go back to school and been rusticated for a year. At the end of the hearing, out of about 200 or 300 students who were involved, the court granted liberty only to 9 of them to be treated as passed. And one of those 9 was my client. And I tell you, I was walking on air that day. It's a tremendous feeling. You made such a difference to a person's life. So therefore, that's one thing. Another one I remember was this Air India pension matter. Air India had a pension scheme. Suddenly, one fine day, they got up and altered that scheme, saying that we don't have enough funds. The matter went to the court, Bombay High Court. It was heard for a period of 3 or 4 days. And I remember at the end of the 4th day, the judges told me I had to rejoin. They said, Mr. Kama, 1 hour and no more. But they heard me for 3. And at the end of that, we succeeded. And then I met one of the judges at a public function one day. He told me, he said, your last 1 hour made the difference. This brings me to the next point. When you walk into a court, remember that you are there as a paid representative of your client. I use the word paid with intention. When you walk in there, you stand in the shoes of your client within the bounds of your job as an advocate. You don't get personally involved. You don't abuse the bench. You don't do anything underhand. But within the boundaries of your professional integrity, you are in the shoes of your client. You have taken his money. In my opinion, you have a bounden duty to fight for him. I remember many of my colleagues out here would say, oh God, Kama's in front of us, we've had it, we won't reach. But I'm not concerned with them. I'm concerned with my client. I go there to court to fight for him. I've taken his money. I owe him a duty. There are some lawyers who will go to court and find the judges against them, so Lordship is right. I don't believe in that. And I would recommend that all of you, when you start practice, remember integrity. If you don't like a client's case, if you feel that you can't win it, don't take it. Don't take his money. But don't walk into court thereafter and surrender his case. Winning and losing is part of the profession. You may win, you may lose. But the only thing that you have to bear in mind is that you must make the effort. And I tell you that one of the greatest compliments as a lawyer that I had ever received was when I lost a matter and the client walked up to me and I said, look, I'm sorry. He said, it doesn't matter. I'm satisfied. That is what you must aim for. Winning and losing is not the point. Of course, you want to win more than you lose. Who wouldn't? But at the end of the day, your client must feel that you have genuinely put in your best effort. Coming now, having said all the serious things to you, let me also tell you that there is an element of humor in the court. There is a case years ago which I was handling here, and I was appearing for this watchman. He was supposed to have assaulted a woman called Diwali Bai. The matter got over, we succeeded. And as I was leaving the court, one of the judges turned to me and said, Mr. Kama, please advise your client to now control himself and not go and attack some Dasera Bai. So there is humor there. Many people who are outside the domains of the court don't know this. There's a case I love to repeat, which I read years ago in the Oxford Book of Legal Anecdotes. The story, as I remember it, goes that there was an English circuit judge in Ireland. The British were never very popular in Ireland, they still aren't. Anyway, he was trying a case where an Englishman's cow had been stolen by an Irishman. The case was open and shut. The theft was palpable. But at the end of the trial, the defense lawyer asked the judge, may I have your permission to address the jury in my own native language? So the judge thought to himself, all right, as it is, they don't like us. Let us give them the benefit of English justice. He said, all right, go ahead. He spoke to them for exactly a minute, at the end of which they came back with a verdict of not guilty. The judge couldn't understand how this happened. So he asked his associate, as we call them, what happened? What did he tell the jury? He said, my lord, he told the jury that the cow is Irish, the plaintiff is English, the defendant is Irish. Do your duty. So things like that also do happen in courts. Coming back to what you should or should not be doing in a court. Never ever tell a deliberate lie or a falsehood. One thing you must always remember that as a lawyer, your integrity is your passport to success. If a judge comes to believe that your integrity is not what it should be, that you're capable of lying, he will never believe a word that you say in court. He will never believe a word you say in court, and he will talk to his brother and sister judges, so that your reputation as a lawyer goes down before the eyes of the bench. And that is a great detriment to being successful in law. I won't say that I have not been any who have done these kind of things, they have. But my advice to you is never ever tell a deliberate falsehood. And if by mistake you do state a falsehood, have the courage to go back to the court the next day and say, Manoj, I'm sorry, I have made a mistake. They will appreciate it, they will trust you in future, and that will go a long way to your success at the bar. Also, you will find sometimes there are judgments. This is a moral issue which often haunts me also. You know that there is a judgment against you. What do? The broader philosophy is that the other side has brief counsel, so he should know the law also. It's a moral dilemma. Should you or should you not tell the court about a judgment which is against you? In my younger days, I wasn't so ethically minded. But now that I've grown older and more confident of myself, I'm inclined to show the judgment to the court and then try and distinguish it. So therefore, there are times when you have to have moral dilemma as to what to do in a case like this. Without that judgment, you're sure of winning. With that judgment, you may not. What do you do? And in my opinion, at this stage of my life, I would say that I would show the judgment and I would do my level best to distinguish it. I have done that. I've argued sometimes on rival sides of the same coin. For example, whether rich can lie against private parties. I succeeded in one court, went to another, showed them a larger bench judgment, which I had not known earlier, and distinguished the earlier one. So what I'm trying to tell you is that it's not easy because you want to win. You're paid to win. But you also have an ethical responsibility, not only to yourself, but to the courts of law, to the system of justice. And therefore, my advice to you is, you will from time to time face that. Distinguish those judgments. As far as possible, don't fall into that trap of hiding judgments. Another thing is, when you cite a judgment, never cite it only on the basis of head notes. Head notes can be drastically wrong. Now, for those who don't know, a head note is a note which is put at the top of a judgment. It is prepared often by the editors of the law review. They will go through the judgment and they will give you the principal points on the top, so that it makes it easier for you. You don't have to go to the entire judgment. My advice to you is, don't ever cite a judgment based only on the head note. The head notes have been known to be wrong. And the classic case of this nature was where a particular judgment in the Bombay High Court had occasion to castigate this. And they said, this is absurd. The head notes are wrong. And the very same judgment, the head notes were wrong. So don't rely on head notes. Also, when you read a judgment, Don't read the portion which appeals to you. Read the entire judgment. I remember a case where in the last paragraph of the judgment, it was a rather long paragraph. It was beautiful in my favor. Every single word used there was exactly what I wanted to argue. But the last line said, we do not agree. So what they were recording was the kind of argument which could be advanced or was advanced. But the last line, they said simply this, we do not agree. So the whole paragraph went down the tube. And had I cited it without seeing that, my own judgment would have sunk my case. So be very careful when you cite a judgment. Read it. I have often had the benefit of judgment cited against me because the person who's citing it, the counsel citing it, has just read a part of it, probably a part which records what was stated by the counsel in that case, perhaps. And he cited that. But the ratio is different. And having gone through the ratio, I have used that very same judgment against that party concerned. So be careful. Don't cite judgments lightly. Another thing is, I just have to get back to what I said earlier. There comes a time when you have a moral dilemma of a different nature. The moral dilemma being, I remember in one particular case, I was arguing in the Supreme Court, and my client's success depended upon my challenging the constitutional validity of the particular statute. Now, if I had succeeded in that, it would have destroyed a large part of the practice of labor law in the state of Maharashtra. As it is, there was an earlier judgment of mine which had had a severe impact on the practice of labor. And I thought to myself that if I succeed in this, I will effectively destroy labor practice in Bombay, and I'm sure the local lawyers are not going to forgive me. So I had a moral dilemma. Should I challenge it or should I not challenge it? By challenging it, I might have won the main matter, but by challenging it, I will have destroyed so many people's careers. What do? I must say, I took the choice that I considered to be the right one. I told the judges, I'm challenging the statute. Fortunately, judges turned around and said, no, we don't want to go into this issue. But this is a challenge. You will face these dilemmas. I once remember telling the Bombay High Court Chief Justice that, my lords, there is a difference between my heart and my head. My heart says go one way, but my head compels me to go the other. You have to make those choices, and you will be faced with those choices as you go along in your career. And the only way to deal with those choices is to look for the moral ground. If you're appearing for your client, do your job. Don't sit in moral judgment over him. The first thing we were taught in law college when we were there was you are not the judge. You are supposed to represent your client. And I repeat, if you don't like his case, if you don't want to appear in a matter of that nature, don't. Give back his fees. Tell him, sorry, I don't want to appear. But don't take his fees and then not do your job. I find that repulsive. And I've seen lawyers doing that. Another thing is, I've learned over a period of time that the way to argue is not to hammer the judge. The way to argue is to convince the judge. Having said that, in my younger days, I was a very hot-headed young lawyer. I had this mistaken impression that I knew more of the law which I was dealing with, my specialization, than perhaps the judges did. So I was very aggressive. Over a period of time, I learned that does not always succeed. That's not the way to go about it. The way to go about it is to convince. Convince them, convince you're right. And there's one secret weapon that I have in my armory, and that is to smile. Sometimes you have to smile to gritted teeth because the judge you're facing may not know the law as well as you think you do. And sometimes they can also be deliberately obtuse. You have to smile. If you smile, you will find it's a human nature to smile back. Try it. See anybody you meet just now, smile at them. Instinctively, they will smile back. And that in a court makes life much more peaceful. You can smile your way through a difficult problem. You can smile your way to achieve what you're trying to argue. There are very few lawyers I know who can hammer the judge on the head and get the law, get the judgment in their favor. In my younger days, I sometimes feel I used to succeed only because they thought to themselves, let's give him what he wants and get him out of my court. But as I've grown older, I've thought to myself, okay, that is perhaps not the correct way to go about it. Convince, not bully. Satisfy them, not try and compel them to see something which they don't believe in. So therefore, my advice to you is when you go before a bench, no matter how difficult the court is being, smile. It has an effect. They will smile back. Another thing is, I don't know, there are lawyers and lawyers. At this stage of my life, after almost 50 years of practice, I still agonize over a loss. People say that if you're a lawyer, you must be indifferent. You must not get involved. But I find it difficult because when I go to court, I have researched it sufficient to feel that I deserve to win. Also, I have in front of me my client's face. So, if I lose, and losing is part of the profession, I do still agonize over it. I still do think of what happened, what could I have done better? And that to my mind, at least my mind, is a good thing. It keeps you on your toes. If you get blasé and you say, okay, whatever has to happen will happen, or whatever had to happen has happened, it might give you a peace of mind at night to go to sleep. And I tell you that there have been nights when I haven't slept properly because of these things. But I personally believe that as a lawyer, you should feel for the client also. You should not be blasé. You should not say that whatever is. That's my belief. There are colleagues of mine who are doing extremely well in the profession who don't believe that. They say, when I walk out of court, matter's over. So it's for each person how they react to these things. My belief is keeps me sharper because the pain hurts. Another thing is, when you go to court, do not ever walk into court without researching your brief. 80% of your success, if not more, is dependent on what you have done outside the court. Your research, your knowledge of the law can make the difference between you and another lawyer who doesn't know or has not bothered to read the law as well as you have. Every month, we get judgments being published by court reporters. SCC Online comes out, AIR comes out, my paper reports come out. I make it a policy to read every Supreme Court and Bombay High Court judgment dealing with with labor. So that is my specialty. And that often is the difference between winning and losing. You see, judges come from all walks of life. They don't necessarily know enough of labor or constitutional law, or indeed any other branch of law that you might be involved in. You're asking a judge who has perhaps in his career as a lawyer done a particular line of law. Now you tell him, sit there and decide every branch of law. He may not know every branch of law. Therefore, it's obligatory upon you to assist him by showing him the latest case law, by showing him what is the judgment or what are the judgments on the field. And that makes a difference between winning and losing. As an aside, I'll tell you, years ago, when I used to go to the tribunals, there was a case I cited for the judge. And he said, no, can't be so. I said, Manoj, this is the Supreme Court. This is not Kama law. That made the difference. The judgment made the difference. Now, a lawyer is only as good as a law he knows. Don't ever imagine that a judge knows all the laws. It's not possible. No human being knows all the laws. So when you walk into a court, Remember that you're there to assist the judge. He does not necessarily know the law that you are arguing before. You have to assist him. That is why justice is a collaboration between the bar and the bench. The tragedy is sometimes the bar, the counsel arguing may also not have done his research. So it's a case of blind leading the blind and you get bad case law. But I always blame counsel for that, not the judges. Because you haven't done enough research in order to show the judge the correct law, because you imagine that he would know the law. He doesn't. He cannot. No individual judge can know every branch of the law. You practice in the Supreme Court, you realize how many different branches of the law, how many local laws there are in different states. So it's your job to get ready with it. It's your job to research it. And then you go into court. There's also a fact of life that lawyers who know the law do not always succeed. If you know the law and you are competent as a counsel, it makes the difference. But it's a sad fact of life that there are many lawyers who know so much more law than many of my senior colleagues do, me included. No issue about that. But they just haven't made it at the bar. Because there is something about a lawyer. In order to be successful, you have to have confidence, you have to have knowledge of the law that you're dealing with, and you have to have the capacity to put across your point of view to the court. That makes a difference between a lawyer who is very legally astute, but not able to argue in a court of law. So therefore, when you become lawyers, if you want to practice at the bar, please realize that just knowledge of law is not enough. You have to be able to convey that across to the other side, and you will be able to convince the other side of it. Okay? Having said that, there's also a question of tactics. Now, again, speaking personally, when I appear in the Supreme Court on a miscellaneous matter, I have to kind of think to myself, what is it that I'm going to open with? Because there, in a miscellaneous matter, they really give you about 2 minutes of, if you're lucky, you get double. In those 2 minutes, what you say can often make the difference between winning and losing. So you have to have a tactic. You have to think before you open your mouth, especially in a Supreme Court, in the miscellaneous board. Even when you're arguing a final hearing, you have to have a tactic. You have to have a flow. You have to have an idea of how you want to take the judge through your brief. So therefore, tactics are also very, very important. And sometimes tactics can be even more important than the knowledge of the law. But I would not underestimate the knowledge of the law. You must know your law before you walk into court. Now we come down to the small element of procedure. What is the most significant part of a lawyer's life? Drafting. Whether you're a senior and therefore you receive a draft and you argue on that basis, or whether you're a junior and you're drafting. Drafting makes the difference also. There are judges who have mentioned them, and some people in my presence. You have said this in your petition? All right. This goes directly against you. You are hoist on your own petard, as the English saying is. So therefore, be very careful when you're drafting a plaint or a petition. My advice to you is gather your papers together in a date-wise order. Do not take a file from your client just as a file. Clients are always full of their own matters. They know every single letter in a thick file. But you don't want that. You first listen to your client, see what is his case. Then you tell him, out of the entire 500 pages, give me the following. Once you have that following, put it in a date-wise order. Why? Because when you're dictating your draft, there should be nothing left out. You should not be constantly worried, have I forgotten something? Have I left out something? Also, if you draft with a date of July, thereafter a date of March, and thereafter a date of October, A judge reading it will get totally confused. So, my advice to all my juniors has always been, when you receive your client's papers, listen to his case first. Understand what the matter is about. Then tell him what documents you want and get those documents in date-wise order. Then your drafting will be fluid. You will go from the top to the bottom. You will not forget anything significant that you need to remember about, and your draft will run beautifully. This becomes much more important when you come to Supreme Court, because in Supreme Court, when I said earlier, you have 60 matters in a day, they have no time. They have no time to try and understand your up and down draft. So drafting is an art. It's not a science, it's an art. Now, how do you draft? You first look up the law. Never ever draft without looking up the law, because you want to draft in consonance with the law and not in a manner which conflicts with the law, which can happen if you don't know your law. So even if the client comes to the papers, and even if you had one conference and asked him, if you're not sure of your law, ask him to come again on another day. Meanwhile, you look up the law, understand the law, and then draft into the law. Now, how do you draft? I've always given an example of a pencil. A pencil has a foundation. It has a body, and then it has a point. Draft in that manner. Draft your facts, lead up to the law that you're arguing, and finally get to the law. You do it that way, then judges who read can also understand what you're trying to say, and you yourself, as a draftsman, will be confident that not only your facts, but also your law is correct. So draft into the law. Draft in a manner which reaches a culmination at the top of the pencil point, which is the law. These are my facts, and based on these facts, this is the law I'm advancing. Now, drafting, therefore, is very, very, very important. Now, when you draft a reply or a written statement, there is a tendency sometimes to just bypass certain paragraphs or to skim over paragraphs. It happens. But as far as humanly possible, deny, if you have to deny, everything which needs to be denied. Or even in a generic manner, deny. What is stated in paragraph so is hereby denied. Don't leave anything out, because there have been cases where judges have said, all right, he has said this, show me your denial. You have a denial. You lose on that denial alone. So pleadings are very important. Always urge whatever you have to, but when you're doing a reply to every point which requires a reply. You would otherwise lose merely on the grounds that you have not replied to a particular point, and therefore that point is deemed to be admitted by you. Even when you advise your clients to write letters to the other side, or when you as advocates write letters to the other side in response to something they may have written to you, deny every single thing which is against your client's case. Do not leave this scope for deemed admission. Now, when you come to procedure, actually, it's also a part of practice. Look at your judge. Know your judge. There's an old saying, lawyer, know your judge. When you walk into a court, especially a strange court, like you go on a matter to another high court, always go and sit in that court before your matter is called out, so that you can see the nature of that judge. What is it that he tends to like? What is it that he tends to dislike? Once you have that, play to his likes and avoid his dislikes. So it's very important for you to know your judge. Study their faces also. When if you're a division bench you're arguing before, study their faces, study the discussion going on. You will get some link, some hint from that as to which way the court is leaning or which way one of the two judges is leaning. Another thing, when you're arguing in court, there's a tendency to look at one judge. Please ignore that. Look at both. Make eye contact with both. Because if you make eye contact only with the senior judge, the junior judge feels left out. I'll tell you, this has an impact on them. Once you are arguing a matter in the Supreme Court, and a particular judge, the two of them were sitting, judgments of the brother judge were cited. And you won't believe it when I tell you the senior judge is nobody going to cite a judgment of mine. See, they feel left out. So when you're arguing before a two-judge bench or even a larger bench, make eye contact with all so that they know that you are not ignoring them. We are all human beings. If a judge feels neglected or ignored, it can sometimes color his view. So therefore, look the judges in the eye. If it's more than two, go up and down the line. Meet them in the eye. When you're also, as a lawyer, I find that there are some lawyers who believe they are mightier than anybody. They don't want to listen to a client. They don't want to listen to their juniors. I know the law. It's full stop. Don't do that. You will often find that although you might know the law, and if you're a senior, you should know something of the law at least, you will often find that your client can come out with something which will make a difference to his case. Listen to him. Sometimes it gets frustrating. Sometimes they get long-winded. Control that in your client. But listen to what he is saying, because he may very well have a point of law which he has learned, which is researched, and which is built up inside him. May not have struck you. We lawyers are not gods. We make mistakes. We lose so many matters because of mistakes we make. So don't make this mistake. Don't think that you're superior to your client. You're there as a representative. Listen to him. Listen also to your juniors. When you become seniors, I have a practice of asking my juniors to take the contrary point of view. If they're briefed to argue a particular point, I'll tell them, okay, now you argue the counter. And I will encourage them to argue with me because it helps me to crystallize my own thinking. So this is also a tactic which I would advise. Many seniors may or may not agree with me, I don't care. That is my advice, that's my practice. I like to listen to the contrary view. And I had a junior who used to argue a lot. And at the end of time, I would tell him, okay, enough. I've heard you. But listen, don't think that you are God Almighty on earth just because you're a lawyer or you're a senior lawyer. I don't believe in it. Lastly, success in the law is dependent on a variety of things. To be honest with you, it also depends on luck. Recently, the Bar Council of Bombay has been holding lectures on from hardship to success. And I've been listening to my senior colleagues describe how from hardship they have come down to stupendous success now. Not everybody has that. Fortunately, as far as I'm concerned, I don't recall any hardship. I was just lucky. But law, there's a lot of questions of, there's a lot of luck in law also. You have to have somebody who backs you. So just because you're qualified, just because you are an LLB, doesn't necessarily mean, unfortunately, that you will always do well. But that also does not mean that you should not try. There's a famous case of a senior lawyer who went on to become Advocate General of Maharashtra. He, for years, did not get work to an extent that he almost was on the verge of leaving it. Then he got one case against a group of senior lawyers. That one case made his life after that. So therefore, what I'm trying to tell you is that success in law is not guaranteed. Just because you know the law, I know many lawyers who know far more law than I do. They've never succeeded because they don't have that one element argue in court. Argue in court also requires that one spark, and you must have that spark. It's tragic because, as I said, so many of them I know who are brilliant in the law, who could perhaps write circles around my own knowledge of the law, but they just never made it. So at the end of the day, what I want to say to you is, what you're about to join is a tremendous profession. It's not a business, it's a profession. It will take you time to rise from start to success. But it is a road which can be achieved. Not everybody does, but it can be done. And always remember what we were told and what I said to you earlier, they always place on the top shelf. That's all I want. It's all the wisdom I have to offer.
Thank you, sir. Thank you so much. Some of the young participants have requested for your recommendations, sir, on any book on the CPC.
Mullah used to be the book. Mullah, I don't know whether this is publishing it because, as I said, I'm a constitutional.
It is.
I thought it is. That has always been the major book on the CPC.
Right, sir. So thank you for that, sir. Keshav, would you like to take over and proceed with the questions?
So again, thank you so much. Absolutely very enlightening and motivating also, I would say. So there is one question from Mr. Satya. Mr. Satya, I request you to kindly take your question up yourself if you can.
Thank you so much for the motivation, sir.
I'm glad you feel that. I was a little worried that I was being a bit of a damper. Anyway.
No, sir. It's really a very big privilege. And right now I am outside in the road and listening to you, and it's like you should be talking in a larger podium. So my question is, I haven't completed my LLB, and due to some personal reasons, I dropped out of studies. Recently, I joined LLB, and I'm practicing under a Bombay High Court advocate. So is it something like a person for me should think about going to Supreme Court and become a member of Supreme Court? No. And I'm somebody who is 30 plus.
No, not just now. Supreme Court is the graveyard of even seniors. So you see, Supreme Court practice is peculiar. There are a large number of young lawyers there who are charging, you'll be surprised to know, 5,000 for an SLP. So life out there is not easy. And if you go as a junior lawyer, why would anybody want to brief a junior lawyer when A, the advocate and record can do such a case himself, and B, why would a wealthy client want to brief a junior? I remember in my younger days, I had to appear largely for workmen because the people who could pay always briefed the senior lawyers. Similarly, in Supreme Court, it's an ocean. And I tell you, there are so many seniors there who have gone from out of town and just haven't succeeded. It's very difficult. Also, there in Delhi, there is a groupism. There are some people who form themselves into a group and they brief that group. So therefore, my advice to you is, okay, wait. If you want to go to Delhi at the Supreme Court, become a senior here. You're 30, okay, you can become a senior, say about 45, 50, 60, something at that time. And then if you still feel you need to go, then go. Don't go as a junior. Especially if you don't have any Delhi contacts.
Sir, I grew up in Delhi.
Sorry?
I grew up in Delhi, sir.
Oh, if you have Delhi contacts, people, local lawyers there who can brief you.
My sister is a lawyer, sir.
Have you asked her?
Not yet, sir, because I feel first I should get a sanad here and start practicing at the Bombay High Court, and then in next 7-8 years I should try for Supreme Court.
Let's be honest now, there must be youngsters like you who are qualified in Delhi and who have gone to Supreme Court. But my advice to you is don't go right away unless your sister can really support you in briefing. And if she can spread the word to other friends of hers, and if you can get a group like that who are briefing you, then go. Otherwise, as I said, it's a graveyard of even seniors. How many High Court judges are floating around? The ex-High Court judges are doing nothing.
I get it, sir. I get it.
So
thank you so much, sir. Thank you so much for the answer, sir.
So again, absolutely fantastic insights, very, very deep, very enlightening.
You're most welcome.
And I'm absolutely in line with how you've conducted the class and how you've mentioned, how you've taken us through what the exact procedure. Actually, if it would have been, if you would have limited the procedure to the book itself, then I think it would not have actually hit the point where it has right now.
I'm glad I could help youngsters.
So,
all the best to all of you who were there.
So it's your blessing, sir,
Welcome.
and it counts greatly. So just two small other points which are there, which I would want. Irrespective, we've completed time schedule for the class.
I can't hear you.
But since we have you with us, and since we've already overstepped the time of the class, I very humbly just want to take up two more points which you mentioned. So one is with respect to, so you mentioned the hardships which come in the profession. So there's a lot of stress which builds up for young professionals. While growing up, how you narrated the story of that senior who later on went on.
I can't hear you. Can you speak a little slowly also? Because it's a combination of your speaking normal speed and I can't hear. So speak a little slower, I might be able to catch it.
Is it better now? So I hope.
Yeah, so if you speak at this level, I perhaps can hear you. Yeah.
Okay. So, sir, with respect to how you narrated the story of the senior who had to go through such hardships to eventually become the Advocate General of Maharashtra. So, what exactly would be your advice to young lawyers who are dealing with stress?
Dealing with
Stress, work stress, work stress, sir. Stress.
stress. Look, this profession is a stressful profession. Let nobody bluff you about it. And it's a funny thing, when you become a senior, the stress is more because people come to you in the expectation that you'll perform miracles. You can't. But it is stressful only from this point of view that as a youngster, you don't get work. It's become very difficult to live in a city. That is the stress. Now, some seniors pay their juniors. I used to pay mine because ultimately they have to survive. But many seniors don't pay their juniors. And therefore, for years on end, there is no income. That is a stress. And the stress of working, very often the stress of working hard without much remuneration can also be a real bummer. No, there is stress, and there is stress at all levels. Even today, when I walk into a court, there is a stress that the stress to succeed, the stress to win. I used to tell my children when they were younger and going to school, I said, don't tell me about your exams. I have exams every day. It's true. Because as a lawyer, you walk into court, you're briefed to win. So that it's a test every single day in every single matter. It's a test. So there is tension. As I said, there are some of my colleagues who are better at it than I am, and they say, "Oh, it doesn't matter, win or lose." I can't get used to that. But all I can tell you is that when you walk into court, you must be 100% ready. If you're 100% ready, your stress volume goes down. And as a lawyer, the stress goes down the moment you open your mouth. Why? Because it's all here. It's all in your head. It's dying to get out. So the stress really is before you walk into court. Once you walk into court, you're ready with the matter, then you're dying to spill it out. And that the stress ends there. Also, talking of stress, it can be stressful when see, at the end of a day, an argument. When I was younger, and I argued a whole day, I used to feel tremendous. I've argued a full day like Josh. Now, it gets very tiring. At the end of the day, I'm wiped out. Why? Because you're concentrating on the bench. First of all, you argue your case. Then you're concentrating on the bench and you're looking at every single thing or motion the judges are doing. They're just trying to find out what is their approach to the matter. So it's not stressful, it's very tiring. People don't seem to understand. So all you got to do is stand up and talk. It's not. First of all, you're standing up. A person like me uses his hands, as you can see. So that is exercise by itself. And then talking with an understanding and an intention to convince and persuade can be very tiring. I wouldn't say so much stressful as it is tiring.
Absolutely, sir. Actually, it's really very nice to understand that it's not just the young people who go through such thoughts and such emotions, but also
Just slowly,
the
Keshav.
seniors.
Slowly.
So how you teach, it is absolutely fantastic, sir. It's really very nice and very, how do I say, it comes through. That's the best part of having an interaction with you.
Thank you.
So just one final thoughts, one parting thoughts from your side. That when we say that we're speaking about civil law and civil procedure per se, so a person who is freshly introduced to the civil law. It may be a practicing advocate. It may be someone who started off doing criminal practice. How I also started my law, and how other people may also be doing, or any person who approaches or who gets the opportunity to approach civil law for the first time. So, what would be your advice to him as to how that person should navigate through civil law?
I tell you, if you were to if you were to study law today in college, I would advise you to take up interpretation of laws, because a large part of your practice, whether civil or otherwise, is interpretation. How you interpret. There are certain tests which are taught. So interpretation of law is the first thing. Now, if you're doing commercial law, then obviously you need to know your Contract Act and your Civil Procedure Code, which is one reason why I don't do civil law, because I don't want to get involved in order so and so, rule so and so, section so and so. I like the broader compass of the Constitution. So, but if you're going to do commercial law or regular civil law, then you must know your interpretation, and you must know your Contract Act, you must know your CPC, transfer of property. These are statutes need to be. You can't learn everything. You will learn as you go along. There is no one subject that I can tell you that you must learn, except interpretation. Whether you do constitutional law or you do civil law, whatever law you do, you must learn interpretation of statutes. So that's my first advice. Right?
So it's again, sir, it's absolutely very enlightening, sir, and how you put things forward. I'm sure that it comes with the kind of experience that you have to be actually to be so humble about the kind of things that you have said, and which I know for sure that, as you very rightfully mentioned, that a lot of young advocates practicing at the Supreme Court today will not be so confident and comfortable in stating so many things that you have actually such truths that you've pointed out for all the participants and for everyone who's going to be referring to this class in the future.
I'm glad. As I said earlier, I wish all of you the very best and great success.
So our success is the fact that you have chosen to come and enlighten us today with such pearls of wisdom.
I love talking to youngsters. My son always tells me enough. But I feel that if after all these years, if I don't pass on my experiences to youngsters, what is the point? So I had you all here for 45 minutes, captive audience.
Absolutely, sir. And I look forward, since you also, I'm understanding now that enjoy interacting with youngsters, that we will have more opportunities and occasions to have this discussion and continue this
All the best.
learning process with you. So I very warmly and very humbly, I thank you on behalf of all of our participants,
All
everyone
the
who has
best.
attended, everyone who's going to attend. So again, a lot of thank yous in the chat, and
All the best to you.
so with your permission, sir, I seek to humbly end the session today.